Everyone needs at least a will, a financial power of attorney, and a medical power of attorney. When you create a will, you need to make several decisions about who will have authority to handle your personal affairs when you cannot. It's very important to put your decisions in writing. Good intentions are not enough. A properly drafted and signed estate plan will speak for you in the two situations where you cannot speak for yourself, if you are unconscious and after you pass away. The following is a brief summary of the decisions required to create your will and related documents. 1. Executor. After you pass away, who should take care of settling your estate? That person will be the executor in your will. Who do you nominate as executor? Typically, someone in your family, your spouse if you're married, your adult children, a brother, a sister, or other relatives. Your executor should be someone you trust. You can name anybody you want. 2. Beneficiary. After you pass away, who should receive the money and things you leave behind? These people will be the beneficiaries in your will. The beneficiaries might include people and charities. Who do you name as a beneficiary of your will? Typically your spouse. If you have no spouse, you might name your children, brothers, sisters, other relatives, or your favorite charities. You can name anybody you want. 3. Guardian. If you have children under the age of 18, who should raise your children if you pass away? That person would be the guardian in your will. Who do you name as a guardian for your children? Typically your spouse or a child's other parent. If you have no spouse, you might name your brothers, sisters, or other relatives. Name someone you would trust to raise your children. You can name anybody you want. 4. General power of attorney. If you are very sick and cannot handle routine business for yourself, such as paying bills, depositing checks, filing insurance claims, etc., who should handle your personal affairs? That person would be the agent in your general power of attorney. Who do you name as the agent? Typically your spouse. If you have no spouse, you might name your adult children, a brother, a sister, or other relatives. You can name anybody you want. 5. Medical power of attorney. If you are so sick that you cannot make medical decisions for yourself, who should have the authority to speak for you? Who should have authority to make medical decisions on your behalf? That person would be the agent in your healthcare power of attorney. Who do you name as the agent in your healthcare power of attorney? Typically your spouse. If you have no spouse, you might name your adult children, a brother, a sister, or other relatives. You can name anybody you want. 6. Privacy Act authorization. Under the Federal Privacy Act, HIPAA, doctors, hospitals, and medical staff cannot share your confidential medical information with anyone unless you give them written permission. If you enter the hospital unconscious and cannot sign an authorization, it's very difficult for the medical staff to share information, even with your family. Who do you name to have access to your medical information? Typically your spouse. If you have no spouse, you might name your children, a brother, a sister, or other relatives. You can name anybody you want. 7. Living will. It's not a will, and it's not about living. It's a very poorly named document. Hospitals are required to ask you if you have a living will, but they cannot require that you have one. Some people want a living will, some do not. If you are unconscious and the doctors determine that you cannot recover, who do you want to be involved in the decisions about what to do? Those people are your living will contacts. Who do you name as the contact persons? Typically your spouse. If you have no spouse, you might name your adult children, a brother, a sister, or other relatives. You can name anybody you want. To find out how these ideas relate to your personal situation and to learn more about how to protect your loved ones, call or email Lutz Attorneys to schedule your no-cost, no-obligation virtual consultation. You and your loved ones will be glad you did. LutzAttorneys.com, 419-578-9211.